Welcome to Counsel Culture, the Business of Law podcast brought to you by Byfield. Welcome back to Counsel Culture, the Business of Law podcast. This week, once again, the monthly litigation and investigations episodes with Gus and Dina. Hello, both. How are you?
Hey, Meg. Good to be back.
Hello, Meg. Hello, Dina. Nice to see you. Good to be back on the podcast.
Yes, lovely to have you both. Let's get started. Let's dig right into it. We've got quite a few nice stories today. So I'm going to start with the latest one that came out, I think, yesterday in The Guardian and The Times. And basically, they were stating that 80 detectives had been mobilized in a criminal investigation into the post office scandal over potential perjury and perverting the course of justice allegations that concerns senior leaders at the post office in Fujitsu. So far, they've said that they've identified around 20 potential suspects. Obviously, that might change over the next few months. And they said that if there are any prosecutions, we shouldn't expect them to start until 2026. Any thoughts on that, both?
Well, this is a huge story that's just completely gripped public consciousness, and so it should. I think what's really interesting, certainly from a communications PR perspective, is how this really came into the public consciousness on such a large scale. You know, the post office investigation and inquiry was ongoing, but the fact that the Adam Bates story and the sub postmaster story was serialized in an ITV drama series is what really caught the public consciousness. And this latest development is huge. I mean, mobilizing a national force of, I think the Times reported 80 police officers for claims of perjury and perverting the course of justice. You know, you can't get more serious allegations than that. And I think it really does just highlight the seriousness of the issue that has come into the public domain in such a way that we're all talking about this, whether you're in the legal sector or not. It's important in the next phase of access to justice. There's been a lot of focus on the case itself and the litigation funding arrangements around the case and the access to justice aspects of that, which we're going to talk about, I think, a little bit later in this show. But now we're really getting into culpability. When we talk about criminal culpability and perjury, it just highlights how serious this case has become on a national basis, and it will, I'm sure, be a barometer of corporate governance moving forward in terms of the outcome of this. So there's some ways to go. We need to wait for the public inquiry. And it's a case that we'll keep on talking about. I think the police investigation won't happen probably until 25, 26. But that means this will remain firmly in the news. And as I say, it will surely have a very significant impact on how this kind of behavior or misbehavior at a corporate level should not be allowed to go ahead in future.
I completely agree with that, Gus. The scandal itself has highlighted serious failures in oversight and accountability. And I think an investigation and thorough investigation, more importantly, is crucial, not only just for the people who've been affected by this to be able to draw a line and get real closure, but also on that point around corporate accountability. We need to have that just to kind of clear up all of the stuff that's been going on and for people, in particular the public, to feel confident that the final outcome has reached its proper conclusion. So, I think I read that it's nearly £7 million that's required to conduct the investigation. Of course, there's questions over use of public funds and things like that will come into the narrative, I'm sure, over the next couple of years. But from my perspective, I would say it's an absolute necessary spend of money to be able to draw a proper line under this and for people to feel that it's completely concluded. So, yeah, it's going to be an interesting one to keep an eye on over the next couple of years.
Absolutely. As you say, if there's any kind of prosecutions that are announced in 2026, because I think the inquiry itself won't finish for at least the next 6 months to a year. we know that regulators are also looking into it, so that they've got their separate investigation. All of this will come into evidence for the police, obviously. So it's kind of, if there are prosecutions, criminal prosecutions in 2026, I mean, it won't go to trial for at least, a year. So it's going to be in the news for a long time. Yeah, it's a fascinating kind of development of the case. I'm not sure if, as you said, Gus, I'm not sure if it would have gone so far if it weren't for, the series that came out in, was it January or February this year? So yeah, the power of the media here has been really, really incredible. Next story. So this week marked the first case management hearing in the Glencore class action over securities. To remind everyone of the case, it's quite complex, but the headline is nearly 200 funds across the world are seeking damages from Glencore over allegations that the company and its senior leadership made misleading statements that covered up corrupt activities. The claimants currently have holdings in the company that total more than $3.7 billion, not dollars, but pounds. And they allege that they've suffered loss as a result of, quote, untrue statements and omissions in Glencore's 2011 prospectus for its listing on the stock exchange, and later in 2013 in its prospectus for its merger with Xstrata. So the class action is taking place in the High Court in London. And it follows the company's admission of bribery and market manipulation last year. Just to remind everyone, it's quite a complex case that was kind of cross-border. So after kind of a massive investigation, a cross-border investigation, the company agreed to plead guilty to a series of charges in return for paying $1 billion in fines and forfeitures in the US, 280 million pounds in the UK, and $40 million in Brazil. So this is just the start of this whole saga. Let's just say that. I don't know when it's going to go to actual trial. I wouldn't expect it to go to trial anytime soon, because of the sheer volume of the case. But what are your thoughts on this, guys?
Well, I mean, this is a case that has captured the attention of the public, definitely, but also in particular the legal community. I think the magnitude that you just talked about, Meg, explains exactly the reasons why it's far-reaching and the implications are huge. I think if we look at the reputational implications for Glencore, I mean, when you're faced with something like this, pretty severe and a bit of a mountain to climb in order to overcome the issues surrounding such a high-profile piece of litigation. I mean, the damage on the corporate reputation is clearly severe, and I think the impact on investor confidence is something that they're going to have to really grapple with over the next few years, not least while the case is ongoing, but then also when they finally reach a resolution and look to the future as well. Their handling of that is going to be obviously crucial, and as we said, it's a very difficult hill to climb with the magnitude of the case. But yeah, I think the way that they communicate with all of those different stakeholders is going to be really, really imperative. I think the systemic nature of the case, and yeah, the deep-rooted allegations of bribery are severe, and I think it could possibly lead to further implications around whistleblowers coming forward and may embolden whistleblowers in the future. So yeah, it's a big case and one that the industry is closely following.
Gus, any thoughts?
Yeah, I would add to echoing what Dina said about the reputational aspects. I think from a litigation communications perspective, what's interesting is, as you said, Meg, this is a cross-border complex case. There's been regulatory findings. It's been in the news for a long time. The point is, when you have a trial, though, all of it is rehashed. And that trial can be at a much later date. As we know, it can take 2 years, 3 years for a trial to be listed. Yeah. Meanwhile, all of this has already been in the national and international media. But for the parties representing both the claimants and the defendants in this, from a litigation communications perspective, it all kind of starts afresh with this class action trial. I know this class action trial is going to be focusing on particular aspects, but all of that past media coverage will be resurfaced now, and it will be done through the lens of role PR. And again, for practitioners and those interested in litigation PR, this is where the through trial PR tactics and strategy becomes really, really important, because you are dealing with the reputational baggage that is already there, and then you're dealing with the legal facts. So as a practitioner, I'm going to be fascinated to see how the media coverage is reported as we go through trial with the various claims and defences, the opening submissions, and I'm sure it will be listed for quite a long trial. So watch this space. We'll see a lot of court reporters there. We will see journalists who have already reported on this, and then clearly we will see where the case goes from a legal perspective. But as I say, it's a really good reminder that when you've had a case going on for this long and then it reaches trial, there is a significant amount of communications and litigation communications that needs to be prepared, both from a claimant and defendant perspective, to ensure that their narratives are told in the most effective, impactful way from both parties' perspective.
It's a really interesting point, Gus, because when a case does go on for so long, or an issue is in the media for so long, I think people tend to think that the media is tired of it, and they almost forget about the issue, even with something so high profile, because of the fatigue that starts to attach to it. So the point you make around stuff resurfacing from a reputational perspective is really interesting, because we see it so many times where you think something's gone away, people are no longer interested in, and then suddenly there's a courtroom full of reporters. So yeah, definitely one to watch.
Meg, how would you be reporting? On Glencore as a former journalist?
I mean, it's going to be interesting, because I think the what you want to go to is the opening arguments, obviously, because I think that kind of sets the tone as to what the main allegations are, and I think they're usually quite punchy. And then what you want to do, because that's going to be weeks and weeks and weeks long. I mean, and the people that will be brought in for cross-examination, I mean, I expect dozens of them. And some of them will have some really interesting things to say. And I think we're going to start seeing a lot of dodgy corporate issues coming up as part of that. And I think that's where journalists will really be digging into it a lot. And I think is the kind of stuff where even during the trial, is you want to get close to people at those funds who might give you background information that you can use at a later date, because you can't really publish much before and during the trial, but you can once it's resolved and once you've had a decision made. So I think, it's not even just during the trial, I think even in the weeks after a decision has been made, you will have kind of deeper feature types of pieces. So it's just fascinating to me. I also think from a communications perspective, the claimant class is all investors, and I think it's much harder for them to get sympathy from the public, given that they've already got quite high funds. So I'd like to see kind of how they're going to approach that from a PR perspective. I'm quite keen to see what the tactics will be, because it's quite obvious that they want to recoup their losses. I get that, but I think for the public to really be engaged into that and thinking, well, this big bank or whatever, they might have lost $1 million or $2 million, but in the grand scheme of things, it's not much. So I think from a human perspective, for the public that's not in the business perspective, they won't really be able to kind of easily have sympathy for that. But I think people in the business community will, definitely. So I don't know. I find it really fascinating as a case. And again, I mean, the trial will be absolutely explosive. So yeah. Next up.
It's an interesting point you raised, though, about a class action where the members are part of the business community, or have, as you say, very, very, very rich banks. And I think it is an important point to you would think about that carefully in terms of public perception, but also the kinds of media and outlets you would be approaching with this kind of story. I mean, clearly this is going to be all over the pages of the Financial Times. So the sympathy to that financial community, I mean, where a loss is suffered, then that's where the legal process should take its due course, whoever the party is involved. But I also think from a litigation comms perspective, you would then therefore be really pushing those levers on how Glencore has conducted itself. And that would that would mean you would elicit more public sympathy at that broad level, whether you're an investor, an investment banker, or a member of the public who's looking at this and thinking, that is another example. We talk about the post office. That is another example of corporate misbehavior at a very high level. Of course, this all needs to go through trial. And so I don't want to prejudge anything, but there is a lot of media coverage out there that's already impacted Glencore's reputation very severely around this. So again, the litigation communication aspects and choosing your audiences and what messages to replay through the media coverage that's already appeared, I think is very interesting. And all of that will be part of the litigation communications armory on both sides, claimant and defendant.
Next up, so this month, the CAT has approved the second ever collective settlement approval order in the rails fares opt-out proceedings. For those who have not heard about this, the settlement was agreed by the class representative and Stagecoach Southwestern Trains, who was one of the three kind of defendants in the group claim, which alleged abuse of dominance in relation to the sale of boundary fares. So that's it in a nutshell. Gus, Dina, what are your thoughts on that? It's quite a big deal.
It is a big deal. It's the second settlement we've had in the CAT, Meg, and I think it firmly establishes the Competition Appeal Tribunal as, the central place that we're seeing in Europe. These claims progressing and now starting to settle. So this particular case was a boundary dispute. It was people doubling up on fares. And it's the second settlement, and there are a lot of cases in the CAT. So I think it shows that the system is working. There are sort of complaints about the speed of the CAT, but I think it shows that it is firmly established as part of the class action, group action regime for competition-related cases. I do know that it's being looked at very closely across Europe, where our European cousins are developing their own class action regimes. I think specifically what's interesting about this claim and case is the distribution of the damages. And clearly, as more and more these cases settle, the distribution of damages is going to be really, really important. So I think there were certain tests in how many people would actually claim the compensation that was paid out. And this case sets some quite specific parameters in relation to that. Again, from a PR and communications perspective, when we look at consumer redress and where consumer harm has happened, and let's remember the whole ethos around these class actions is to make good a public harm, and we're doing that via compensation. It is really, really important that those people who have suffered that harm therefore receive their compensation. And I think this is where it gets really, really interesting. And the CAT is looking at distribution, how many people claim, how those damages go to those people, or what happens if those damages aren't recouped. In this case, I think Stagecoach actually holds on to the damages until they're claimed by the group. And that's interesting. It's not paid out immediately. So I think distribution of damages, getting to the consumer from an access to justice perspective, is going to be increasingly important. And again, coming back to the PR and communications aspects of this, there is a really significant role that PR plays in that, in relation to communicating with the class throughout the life cycle of a claim. And these claims, as we know, can go on for a very, very long time. So really good news. We've had our second settlement in the CAT. We're going to expect more. The system is working, and it's working well in my opinion.
Yeah, just to add to that, I mean, from my perspective, this is just a big win for consumer rights. You talked there, Gus, about consumer redress, and reaching the second settlement in the CAT is such a big step in that. I think from a defendant perspective, it's a bit of an alarm bell. These are real cases that you're going to have to defend and eventually pay out on, whether that's through a judgment at the end or through a settlement, as we see here. So I think we're going to see more and more defendants waking up to these kinds of cases and thinking about how they can best defend themselves against it before there even gets to the litigation. So improving their price transparency and other governance issues to try and mitigate against some of these claims being brought against them. From a communications perspective, if you're defending these types of claims, well, you've got a lot of reputation work to do if you've got these kinds of allegations against you. So having a really robust communication strategy in place, I think in this instance, which focuses on your governance structures and how you're making changes to those as well for the future, to try and think about that reputation rebuild and rebuild some of that consumer confidence back into your business, is going to be really, really crucial. So yeah, great from a consumer redress perspective, and definitely one for the corporates to wake up to.
And do you think, Dina, that because we're starting to see settlements from a defense perspective, because again, these claims go on for a long, long time, and question how much reputational damage does one claim actually inflict on Stagecoach or an Apple or Google? So do you think once we've had a settlement like this, it raises more alarm bells for the defendant?
You mean in terms of, because there's been a settlement, that people should be more aware of the reputational risk attached to them?
Yeah.
Yeah, I mean, I think that obviously you can settle without admitting liability, et cetera, but I think there is always a fine line to strike in terms of how that's perceived from a public perception point. So I think ultimately, yeah, I think it does raise more alarm bells, because people know that they can reach these settlements. They know that these companies are going to pay out, and they also know that the CAT is going to approve them. So I think definitely corporates will be having to be more aware that they may ultimately pay out.
Last story of the day. So as everyone knows, we've got an election coming up in early July. As a result of that, a lot of kind of bills have been, well, removed from have been removed from the plan. And that includes the Litigation Funding Agreements Enforceability Bill. So that's quite a big deal, because obviously this bill aimed to reverse the impact of the Packard decision that came out last year in the Supreme Court. And that decision rendered most litigation funding agreements completely unenforceable. So that was quite a big deal for the class action space. What do we think? Do we think it's going to be back on the table with the next government, whoever that might be? Do we think, I don't know, what are your thoughts, guys?
I think it will be back on the table quite quickly, Meg. And the reason for that, I'm interested to hear your views as well, Meg. But the reason for that is because it's got a lot of cross-party support. But it goes back to the point we made earlier, that the reason PACCAR's really come into the public consciousness even, it's a very technical legal ruling on the enforceability of third-party agreements, which clearly is a really important point to have clarity on. But the reason it's become into the headlines more so than it normally would, arguably, is because of Alan Bates writing about how important litigation funding was for the sub-postmaster's case. Indeed, without litigation funding, that case would not have gone to trial. And the conversation we were having earlier, interesting, would we be having that conversation right now? I mean, that's the significance of the third-party funding in that case. So there's still a real access to justice element here. And I think if we're thinking about potentially, and it looks very likely we'll have a Labour government, then access to justice for consumers and consumer rights and righting consumer wrongs, I think should be right at the top of any Labour Party's agenda, given their political standing. In terms of more broadly, I think we are in a little bit of limbo now in relation to the enforceability of funding agreements. And I think for the third-party funding industry, this is interesting because it raises all those issues about access to justice, and there are criticisms about funding and how funding works and the role of funders in access to justice. I think that funding plays an integral and important part in access to justice. Class actions tend to always have a funder behind them. So we do need clarity on this. And then there's the point about regulation. And I think that's going to be really, really interesting in relation. Does the third party funding industry need to be regulated? to essentially protect consumers' rights, to make sure that we know where the funding is coming from, that there are proper checks and balances in place. And I know some parties in the funding industry welcome that we do need regulation. Others will say that self-regulation is enough. But let's see where we get to in terms of a new government. And the regulation point, I do think, is an important part of that whole access to justice debate as well.
Yeah, I think the conversations around the PACA reversal got pretty interesting in the last few weeks. There were lots of people starting to contribute to that conversation from different perspectives. So it will just be interesting, I think, to see where we come out of that once we get a bit more clarity and the elections taken place. But yeah, to answer your question, Megan, in very, very short terms, I think it will definitely be back on the table very, very quickly.
Well, one would hope so, because as you say, the access to justice element is so huge here that it would be a shame if it wasn't. But on that note, we're going to end the episode here. Thank you both for joining me this week again. And we'll be back next month for the next litigation and investigations episode. Thank you both.
Thank you, Meg. Thank you, Dina.
You've been listening to Counsel Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week, where we'll be discussing some more of the biggest stories in the legal sector.